Good afternoon. I see we have some survivors from yesterday, maybe a few new faces. I'm Father Jim McCartney. I teach in the philosophy department. I teach philosophy of law, healthcare ethics, philosophy of medicine. And Michael Moreland can introduce himself. Each of us is going to do about half of this paper. And it's entitled, as you just heard, Implications of the Genetic Information Non-Discrimination Act, which is shortened to GINA, of 2008. So when I refer to GINA, that's what I'm referring to. On May 31st, 2008, President Bush signed the Genetic Information Non-Discrimination Act of 2008, GINA. This law, a culmination of a 13-year legislative saga, protects consumers from discrimination by health insurers and employers on the basis of genetic information. The purpose of this paper is first to discuss the discrimination against persons with AIDS and HIV in relation to insurance coverage and employment, then to see what remedies were applied to these situations. After that, we will briefly discuss discrimination that has been documented in health insurance and employment towards persons with genetic anomalies. We will then look at some of the legal protections that have been used in an attempt to prevent genetic discrimination. We will analyze the history and content of GINA itself, and finally we will consider some economic and ethical issues which question both the appropriateness and the adequacy of the protections afforded by GINA. Discrimination against persons with AIDS and HIV in health insurance and employment. When generations look back on the 20th century, it is likely that they will remember the final decade not for its technological advances, but rather for the plague which ravished its people and the society which stood by and watched it happen. This harsh judgment of T.S. Juice has a fair deal of accuracy. Persons with AIDS lost insurance coverage, jobs, homes, and their dignity. The lessons learned from age discrimination have prompted the development of the GINA legislation. Thus, it might be helpful before discussing GINA to consider some arguments made in the context of AIDS about health insurance and discrimination in employment. In an article published in the Hastings Center Report almost at the beginning of the AIDS epidemic in 1986, Gerald Oppenheimer, professor of health and nutrition sciences at Brooklyn College, City University of New York, and Robert Padgug, director of research and analysis in the Corporate Planning and Strategies Department, Empire Blue Cross and Blue Shield, made some discomforting observations and recommendations. First of all, they correctly point out that the United States needs, including payment for health care. But they go on to state that health insurance as it has developed in the United States is very conservative. It requires a high degree of knowledge of utilization patterns and risk, and it is not adequate for unusual, epidemic, or very expensive diseases, or for groups of persons believed to be higher than average healthcare users. It is precisely on these grounds that AIDS threatens the private health insurance system. Representatives of the Health Insurance Association of America and the American Council of Life Insurance seconded this view. In a 1987 commentary in the Harvard Law Review, lawyers representing both these groups stated, because the fear of an AIDS epidemic is very real for certain groups in our society, applicants for life insurance who believe that they have been infected with the virus very well may misrepresent their health history or their present physical conditions when applying for coverage. As representatives of an industry that endorses AIDS-related blood testing to ensure the equitable treatment of all insurance applicants in the underwriting process, we must address the inevitable consequences of effective underwriting. The denial of health insurance to some high-risk applicants, particularly those with HIV infection. Experience has shown that AIDS has not, in fact, threatened the private insurance industry. In fact, Oppenheimer and Padgug, in an article written in 1994, state that as the epidemic has unfolded, it is increasingly clear that such assertions about AIDS threatening the health insurance system were highly alarmist and indeed self-serving on part of some of in the health insurance industry. Nonetheless, positions like the one presented earlier have prompted Congress to be proactive in protecting the insurance coverage of those who, through genetic testing, might discover that they have a genetic anomaly that might lead to a disease or illness. Oppenheimer and Padgug's dispassionate argument for refusing insurance coverage for persons with AIDS goes further. After analyzing the cost that employers would have to pay for AIDS-related disorders in the future, they point out that some cost-conscious employers have already attempted to fire AIDS patients summarily or preemptively to exclude AIDS from their insurance policies. They conclude by suggesting the more effective and equitable policy would be to federalize the problem by legislating the extension of Medicare benefits to all AIDS patients. But there were counter-arguments to the position proposed above. In a different commentary in the Harvard Law Review, Benjamin Schatz argues that the real question then is who should pay for AIDS-related medical expenses. For two important reasons, it is clearly preferable to place primary responsibility on the insurance industry. Second, the very function of health insurance is to pay for medical care. Ironically, the insurance industry has long resisted legislative proposals for national health insurance, insisting that it is in a better position than the government to manage health care costs. It should not be allowed now to use socially harmful underwriting methods to shift onto the government a burden it deems unprofitable. Norman Daniels astutely points out that it is HIV epidemic that has most dramatically raised public concern about underwriting practices for medical insurance. However, these concerns have not led to any appreciable legislation to protect persons infected with HIV from being directly rejected for health insurance, and early case law affirmed the right of employers to drastically limit health coverage for persons with AIDS. One of the first cases to address discrimination in health benefits in AIDS was McGann versus H&H Music Company. In this case, John McGann brought the claim of discrimination and violation of his rights under the Employment Retirement Income Security Act, ERISA, because the music company had made changes in their health insurance program that reduced benefits for persons with AIDS from $1 million to a maximum of $5,000, change or terminate the medical plan under ERISA. Thus, the suit never went to court, and this decision was affirmed on appeal. In a case in Georgia based on similar circumstances, Owens versus Storehouse Incorporated, the courts followed McCann and granted the defendant's summary judgment as well. Gies points out that as a result of this finding, the Owens decision places employees with AIDS in a precarious situation. An employer may now retroactively modify or terminate an employee benefit plan based on medical costs for pre-existing conditions, as long as the modifications are not made to retaliate against the employee or deprive him of existing rights to which he is entitled. There have been local, state, and federal laws enacted to protect workers' rights, including the rights of persons with HIV, but these do not directly deal with discrimination in health insurance coverage. With regard to AIDS, the Americans with Disability Act, the ADA, prohibits employers from discrimination against anyone with HIV disease, and the United States Supreme Court has interpreted the ADA to cover persons with asymptomatic HIV infection as well as persons with full-blown AIDS. In an historic case, Bragdon versus Abbott, the court held that even asymptomatic infection substantially limits the major life activity of reproduction and thus is covered under the scope of the ADA. Genetic discrimination. This information on AIDS discrimination in health insurance and in the workplace provides a backdrop for the development of protections for persons who, as a result of genetic testing, could be discriminated against because of some genetic anomaly or disease. The question made clear in the context of AIDS is, should insurers have access to the genetic information of those covered by their plans, and should it be permissible for insurers or employees to discriminate against those with certain genetic characteristics? Genetic discrimination can be defined as discrimination against an individual or against members of that individual's family solely because of real or perceived differences from the normal genome in the genetic constitution of the individual. Of special concern to policymakers has been the possibility of genetic discrimination in the workplace and in the provision of health insurance. The recent experience of AIDS discrimination described above has certainly led to this concern, but there have been incidents of actual genetic discrimination as well. Concern about access to genetic information by health insurers has historical support. In the early 1970s, several insurance companies discriminated against individuals who were carriers of sickle cell anemia, even though they were quite healthy. The use of genetic screening to identify workers who may be particularly sensitive to noxious environments has been the principal concern about workplace genetic testing, even when done for benevolent reasons. With the possibility of putting their current or future employment at jeopardy, people who might benefit from the use of genetic tests may not undergo these tests if the results are made available to their employers. And this is doubly compounded because people are worried that if they are not hired or lose jobs because of some genetic anomaly, they will in all likelihood lose their health insurance coverage as well. Michael will talk about the actual legislation and some of the questions about it.
With those comments by Jim as a backdrop, one might wonder, given the lesson of experience with HIV, what sources of opposition, if any, there were to enactment of the Genetic Non-Discrimination Act. And the fact is that it was a long time in the making. I first encountered this issue almost a decade ago. In fact, the first bills were introduced in Congress in 1995 by Senator Olympia Snowe, who kept fighting for it and was eventually successful this most recent year. And the fact is that the insurance industry, I suppose one could summarize the argument by saying that the insurance industry prevailed for a long time, along with the Chamber of Commerce and other stakeholders, in convincing Congress that there really wasn't much of a problem, that either existing statutory protections were sufficient to protect against genetic discrimination, that just wasn't much of a record of either health insurers or employers discriminating on the basis of genetics. But nonetheless, in the years preceding enactment of GINA this year, 34 states had enacted some form of non-discrimination legislation at the state level. Some state statutes govern the conditions under which genetic tests could be administered, including prohibitions on requiring tests for employment. Others allow tests to be used for investigative or employee safety purposes only. But as I say, beginning in the 1990s, a more insistent call for federal legislation began to be heard. And as Jim said at the outset, in 2008, just in May, President Bush signed the legislation. The primary features of GINA as enacted following this decade-long debate are directed, as I said already, at insurers and employers. Health insurers are prohibited. Insurers and employers are prohibited from requiring genetic tests, and the privacy protections of the Health Insurance Portability Act were strengthened. Group health plans are permitted to obtain genetic information for purposes of payment as it's defined in the statute, such as obtaining premiums, determining eligibility, billing, claims management, collection, and the like. Essentially, insurance activities that don't involve underwriting itself. Underwriting just simply means the rules or determination of eligibility, computations of premiums or contribution amounts, or other activities relating to the creation, renewal, or replacement of a contract for health insurance. Despite the sweeping protection offered by GINA, though, the statute contains some important limitations that were insisted upon by the employer community and by the insurance industry. For one thing, the provisions related to health insurance are enforceable only by the federal government. That is, that only the Secretary of Labor, the Secretary of Health and Human Services are empowered to enforce the provisions of the statute against health insurers. And there's actually, as I was reading the statute carefully, there's actually an open question that will be a hot litigation topic, I'm sure, for the next year or two, about whether the employer provisions, that is, the prohibitions on employers using genetic information in discriminatory fashion, allow for private right of action. That is, if you claim that you are the subject of discrimination on the part of your employer, can you go to court, as you could, for example, for a claim of gender or racial discrimination under Title VII of the Civil Rights Act of 1964, bring a claim in federal court, or is that also only subject to enforcement by the government itself? It's actually a little unclear. The Supreme Court presumptively disfavors implying private rights of action in statutes, but we'll probably see this issue resolved the next year or two. Also, and importantly, forms of insurance other than health insurance, most importantly life insurance, are not included within the prohibitions on the use of genetic information. And finally, the drafters were careful not to limit the ability of health insurers to underwrite based on current and manifest health conditions, leading some to wonder what effect in the end GINA will have on the actual practicing of underwriting by the insurance industry. But in light of this background and strong bipartisan support for eventual passage, it's hard to imagine that there is any other side of the debate. Indeed, I think the vote in the House of Representatives, there was only 1 or 2 negative votes. But in his book, Forbidden Grounds, University of Chicago law professor Richard Epstein famously and controversially contended that employment discrimination laws are unable to achieve efficiently their goal, in fact, of eliminating discrimination. He later extended that argument to an article on genetic discrimination legislation in the Boston University Law Review in 1994. He makes the provocative suggestion there that the plea for privacy in genetic discrimination is often a plea for the right to misrepresent oneself to the world, and that such privacy is of healthcare financing at some cost, with technological improvements causing a cost could be incurred by some, but not by others. Though attention to escalating healthcare costs has, as we all know, led to a system of managed care arrangements and employer-provided benefits in which costs are held down through assigning an amount of coverage for groups of patients, that is, capitated costs apportioned on a per-head basis, the third-party payer system is largely intact. Lacking a more systematic approach to healthcare financing, a free market distribution of healthcare resources tempered by limited legislation and threat of litigation, that all determines how resources are allocated on healthcare in the United States. Individual risk assessment is used by health insurers to charge appropriate premiums based on a person's likelihood of requiring expensive medical care. An alternate manner of risk assessment based on communal and distributive risk might be a better alternative, but such is not the usual practice. The widespread use of individual risk assessment, of course, leads to a pointed objection to such genetic anti-discrimination laws as GINA and its state analogs. Given that insurers can use medical information that is statistically predictive of a person's health in a wide variety of cases, how can a principal distinction be made between acceptable types of information and genetic information? If a genetic predisposition may underlie a condition but does not directly cause it, in the case of, for example, breast cancer, should that disease be considered a genetic disorder? For example, an insurer might require a test for high cholesterol or for occult fecal blood in order to determine the level of risk for heart disease and colon cancer, respectively, and that's fine under existing law. Why distinguish between some acceptable forms of discrimination, then, against those with high cholesterol or occult fecal blood, and non-acceptable forms against those who could be determined with some certainty a genetic predisposition to cancer, heart disease, and the like? One response might be that acceptable forms of insurance discrimination are based in voluntary behavior, eating fatty diets leading to high cholesterol, smoking, not eating enough fiber, whatever. And genetic discrimination is based in non-chosen characteristics. Complicated interaction, though, between chosen behaviors and genetic background causes health or illness, and no line can easily be drawn. It is here that those who advocated passage of genetic discrimination legislation, and now all of us together, have to bite the economic bullet. They might argue with John Beckwith and Joseph Alper in the Journal of Law, Medicine, and Ethics that genetic anti-discrimination legislation should be rewritten to prohibit discrimination based on any predictive medical information, since virtually all such information has at least some genetic component. In an arena of escalating healthcare costs, such a proposal would shift the burden of insurance coverage to a wider population, but the consequence, of course, is that some or many might lose their coverage due to overall higher costs. As Richard Posner, judge on the Seventh Circuit and another Chicago School economist, observes, anti-discrimination laws can be a boomerang against the protected class as employers take rational measures to minimize the impact of such laws. Such rational measures would include not providing health insurance for anyone at all, where the cost to rise to a level such that employers could still obtain skilled workers without providing benefits. Moving briefly to some theoretical considerations from the practical and legal economic dimensions of the discussion, we would argue that the debate over genetic discrimination must ultimately come down to a question of how one understands the terms of the debate and which factors will be determinative in the legal analysis. For example, is genetic information akin to one's right of privacy to a diary? How does the 20th century specter of eugenics govern our discussion of genetic discrimination, and should it at all? More importantly, what is the significance of appeals to equality? Also at issue is how the very terms disorder or disease operate within such an appeal to equality. Some have argued that all such terms are socially constructed and that no norm exists whereby genetic normalcy might itself be a useful category. Susan Wolf of the University of Minnesota writes of the fiction that there is such a thing as a normal genotype, and that the goal to change the treatment of people who deviate. The reality, though, she writes, is that there is enormous genetic heterogeneity, with all of us harboring genes capable of expressing themselves as deleterious diseases and disorders. GINA now requires insurers and employers and consumers to bear yet additional costs, but the same social consensus that eludes us on the question of healthcare finance did support the increase of costs through anti-discrimination legislation that we all have now. Ideally, a better way to finance healthcare could be found so that the high cost of insuring those with genetic disorders would be more rationally absorbed. Otherwise, as Epstein notes, at bottom there are only two pure forms of legislation, productive and redistributive. Anti-discrimination is always of the second kind. The form of the redistribution is covert, it is capricious, it is expensive, and it is wasteful. While we agree that GINA addresses a pressing problem in the underwriting practices of insurers and protects employees from discrimination by their employers, it remains true, as argued by the authors of a recent article in the New England Journal of Medicine, that GINA is reflective of a haphazard approach to healthcare reform that creates new problems even while it solves some old ones.
Thank you very much. Do we have questions for our presenters? McCartney? Any questions?
Thank you.